Remember the turmoil during the last election? Good old boy Sheriff Vic Williams did whatever he had to do in order to keep his throne. At that time, nobody knew what to believe, but these documents prove that your sheriff and many within the county targeted Johnson and intentionally misled the public. In January, the judge ruled in favor of Johnson, denying the county's request for summary judgment. Yet, the county hasn't settled. The importance of understanding what it means to be denied a summary judgment is crucial. Stick around and I'll explain. But first, let me show you why the judge reserved Johnson's request. As since it was reserved, it's not addressed within the memorandum of law we are going to break down within this video. However, it's equally as important as you're about to see. I was going to skip the background portion because most have already heard the allegations, but I didn't realize that during the investigation into Vic regarding the leaking of private data, Vic's phone, work, mind you, and Facebook both became suddenly unavailable. It states, however, the record is clear that both Sheriff Williams' cell phone and Facebook accounts were no longer available, so any potential data relating to the Soldo phone report could not be disclosed. And that's the possible spoliation. One might argue that the purchasing of new work phones for himself and closest buddies is suspicious enough, but add in assuring the rest of the department that it won't happen to their phones? Didn't think we knew, huh, Vickmeister? Anywho. By reserving Johnson's request, the judge is allowing the matter to be heard by the jury if it comes to trial. The jury will decide if this qualifies as spoliation of evidence. Given everything within the file and Williams' history of being found not to be credible in similar lawsuits against him, I think it's fair to assume it was intentional. By reserving it for trial, the judge is agreeing that there's enough reason to doubt our sheriff's motive. We already know Williams hired an investigator on the taxpayer dime after Johnson was terminated. Therefore, Johnson was no longer a county employee, and this investigation itself should be considered theft of public funds. Furthermore, the sheriff had Johnson's phone in his possession since placing him on administrative leave over a year earlier, ample time to have conducted an investigation. But this guy didn't want this guy to win the upcoming election. Plaintiff was placed on administrative leave beginning February 23, 2017. On the timeline. The charges were subsequently dismissed March 19, 2018. On the timeline. Effective May 23, 2018, plaintiff was terminated. On the timeline. Sometime in June 2018, Soldo was hired again. On the timeline. Take a moment to let that sink in. Bryan was already fired. Was Vic trying to cover his butt for the retaliatory termination by looking for some new excuse? Or was he pissed that because Bryan wasn't charged, he could still contend for sheriff? I believe Vic was willing to do anything to stay in office. Since Bryan was the only man willing and worthy enough to challenge that, he did all he could to punish him. But nothing was working. Not putting him on leave, not trying to get him charged with a felony, not even firing him. I don't think Vic could stand the thought of someone who helped Detective Bliss win his lawsuit against him by telling the truth, taking his position. Good old boys don't lose. We have to stop voting in the good old boys, their pawns, and the ones that protect them. I know that may have felt like a sidetrack, but to fully grasp the concept of spoliation of evidence, you must understand the motive behind the sheriff destroying his phone and removing his Facebook. Too many coincidences to ignore, and there's too much at stake this election to ignore anything. We want the good old boys club out of office. If you or anyone else has additional information regarding these crimes against Bryan Johnson or anything related to the corruption in Itasca County, please contact me directly. Your identity will be held in strict confidence. What, did you really think I was going to say to report it to law enforcement? I won't trust local law enforcement until Johnson's elected. So let's delve into the documents. I'm going to wing the presentation on the following pages, reading parts and summarizing others. The full document is available, and I will gladly send it to anyone who writes me or at Forefathers Daughters page requesting it. The court explains what is required for the defendants to be granted the summary judgment they requested. In this case, the defendants are Vic and his cronies. If Vic and his cronies were to win this, it would mean that the entire lawsuit against them would be thrown out. For Bryan Johnson to win, he has to meet 3 criteria, and they're called elements. And his evidence has to be, on its face, reliable. For the average person to look at and say, you know what, this is probably true. And if he wins this, it's very likely that a lawsuit will go in his favor. So he has to prove that he had engaged in protected behavior and that the sheriff retaliated against him, and then show the connection between the two. And then it also says the plaintiff must also prove that the stated reason for termination is pretext, meaning that the employer lied about the reason for termination, which they do get into later in the memorandum. This next page is all about the protected conduct, and we will jump right into that. So the first thing that Johnson brings up is that he was subpoenaed to testify in another lawsuit against Vic and his cronies, which was actually won, and that was the one with Bliss. And the county's saying that that was not protected conduct. And the judge does not agree with the county. They find that it is protected conduct. It states, in this case, plaintiff was under subpoena and gave testimony to support Lieutenant Bliss's claims of retaliation by the sheriff during the arbitration hearing. Viewing this evidence in the light most favorable to plaintiff qualifies it for protected conduct under the statute. Boom! Nailed the first element right off the bat. I don't know how much more cut and dry this could possibly be. Bryan Johnson was subpoenaed to testify in Lieutenant Bliss's lawsuit, and he told the truth, and it was not a truth that the sheriff particularly liked. And now he is also being retaliated against. That's what you're supposed to do. You're supposed to just tell the truth. At no time should there even be a discussion with the victim, in particular, Carlson, about how it may impact the perpetrator. Since he nailed the first element, we're going to jump ahead to adverse employment action. This last paragraph really sums it up on this page. Evidence showing that the employer commenced an investigation and kept him on administrative homebound leave for a lengthy period inconsistent with the alleged investigatory reason for placing him on leave has presented a material fact dispute as to whether the employer's actions penalize the employee. And he nails it right off the bat again. It's difficult to reconcile that a 15-month suspension was necessary to resolve an issue of alleged false reporting of 12 hours of time. And then they go on to say, termination from employment is the ultimate adverse employment consequence. So now we can move on to the third element, casual connection. This might be one of my very favorite parts here. So remember that this is a judge speaking, so this is the court telling you this. To establish the third element, they had to connect the two. So his conduct and the sheriff's response. So we're heading down towards the bottom here, the first read up there. The placement on leave and initiation of a criminal investigation relating to 12 hours of inaccurate time recording could be seen as an extreme consequence for such behavior and provides circumstantial evidence of retaliatory intent. The evidence that these charges were subsequently dropped, but plaintiff was still terminated, lends further support to a retaliatory motive. Now to the orange. The parties have both referenced the county's multiple instances of alleged retaliatory conduct within the sheriff's department during a relatively short time frame. And there they list them. This history calls into question a pattern of conduct by the employer of retaliatory conduct. Yeah, that's your sheriff. The court also finds the timing component satisfied as well, but I like the way that they describe it on the next page a little better. Under the circumstances, plaintiff has provided sufficient facts when viewed in the light most favorable to him of a casual connection given his testimony at the Bliss arbitration hearing. Further, there is other evidence in the record that indicates Sheriff Williams called plaintiff immoral, unethical, a liar, and ain't my favorite guy, as well as the overall claim of favoritism and retaliation within the department. This evidence qualifies as other evidence of retaliatory motive that bolsters the time nexus in this case. So, boom, nailed the third element. And this is where it starts getting really interesting, and I'm going to stress again, this is what the judge is saying, based on the facts. In evaluating plaintiff's conduct and looking again at any adverse employment actions thereafter, we find that the extended administrative leave continued for some 15 months. There was the initiation of 2 extensive internal administrative investigations related to plaintiff's time card issues and cell phone use, the first of which was initiated in February 2018, approximately 1 year after plaintiff was put on suspension. So, did you catch that? The first investigation wasn't even initiated for a year after suspension. Conveniently during an election year. Allowed to be heard. The county first alleged the suspension was not disciplinary, so therefore not eligible for the grievance process, and then that the ongoing criminal investigation prevented any action. A legitimate inference from the evidence presented is that the gap of time between the protected activities and any adverse employment activity was created by the county's own investigatory measures, or lack thereof, which resulted in plaintiff's ongoing claim of retaliation and excessive discipline. Yeah, it was the county's own fault. That's what the judge said. Remember, this is a judge, okay? This is a judge saying this. In this case, it is the county's inaction that creates the problem and an inference that the extended leave was retaliatory. Then the county's initiation of 2 additional investigations resulting termination after the criminal charges were dismissed provide a further pattern of adverse actions taken by the county and therefore help to satisfy the causation requirement with respect to the grievances. So yeah, boom! Johnson not only nailed all 3 elements, but he just nailed the causation requirement. Plaintiff meets his burden of showing pretext, either directly by persuading the court that a discriminatory reason likely motivated the employer, or indirectly by showing that the employer's proffered explanation is unworthy of credence. Hello, Itasca County. Why haven't you just settled? Hasn't Vic already spent enough of our taxpayer money on the investigations and on the attorney's fees? I don't know. But I think the taxpayers would rather you settle than spend another $250,000 or so on, say, taking this to trial. Yeah, you remember how I said earlier that Vic should be charged for that investigation that took place after Bryan was already fired? Yeah, that should be a felony. That's felony theft of public funds for his benefit, retaliatory benefit, election benefits. Well, the judge does seem to agree, as we see in this page. The phone forensics investigation alone cost approximately $10,000, exclusive of Soldo's earlier investigations. So, I think I read somewhere it was like 10 to 15 grand for the other one. So that's 25 grand, and then you figure in your attorney's costs. So by the time we got to this January, I bet it was upwards of $50,000. And the judge goes on to say, these facts raise a question as to whether such action was meant to find additional reasons to justify plaintiff's termination, and whether it was the county policy to spend thousands of dollars to investigate time card violations of employees. In addition, plaintiff also provided evidence from other deputies employed by the county who acknowledged the time card issues were common and typically easily resolved, without an extensive investigation, and certainly didn't result in termination. And there is also evidence that other employees who were under investigation for criminal matters were not placed on extensive leave. All right, so this argument by the county is just ridiculous. Defendant argues that they are entitled to summary judgment because the data released is not protected. There is insufficient evidence it was released by the county, and no damages are established to support a claim. Are they seriously that big of idiots? So, yep, the county tries to say that the second investigation was part of the disciplinary action relative to the time cards. But the judge does not agree. He says, since the Soldo phone report was not even completed until after the conclusion of the arbitration, the court finds it was not part of the arbitration proceeding. Do y'all realize the importance of that statement there? The judge is telling us that that investigation had nothing to do with the disciplinary action. Why is he still our sheriff? What exactly is our county doing here? Additionally, as plaintiff points out, the county's own witnesses, Attorney Lepak, Skiles, Sheriff Williams, Hart, and Walker, all indicated the Soldo phone report was private, non-public information, and shouldn't be released, even after plaintiff's termination. Alright, so you guys already acknowledged that, and yet you filed a response with that as one of your arguments. Seriously? Is Attorney Lepak the one, doing this? Are we paying for that? That's humiliating. I can't determine what is more embarrassing, that you tried to say that it wasn't public information, or that now you're arguing that there's insufficient evidence to show the report was released by the county. Oh, why? Because you destroyed it, Vic? No. I don't see any charges pending against Soldo, who could possibly be the only other one to have leaked it. What is this argument? It is evident from the evidence submitted that Investigator Clefman, who investigated the MGDPA claims, originally believed a county official would have had to have given it to somebody outside of the county in order for it to get out to the public. Yeah, I think that's pretty cut and dry. And I find it hilarious that the Herald Review will publish what they know to be a leak of private data, but they won't talk about the outcome of this? Yeah, this is your county, that's your newspaper. Cahoots, anybody? It's sick, and they have to be stopped. And just for funsies, here's part of the background where it talks about the leaking. Otherwise, that was nearly the last page. There was a paragraph on the end just summarizing basically what it also said on the first page. Read it yourself. I am shocked, humiliated, and ashamed of this county. These arguments, for one, they're public pretender BS. And I couldn't even get my public pretender to make an argument. Never mind file something so ridiculous in court. It's embarrassing. And it's costly. And that's what we keep voting in. Just put your blinders on and vote them in, because you know their name and you know their face. Yeah. Way to go, Itasca. Way to go. I think it's time for some vindication. So, to conclude, Sheriff Vic Williams was found by a judge to have shown a pattern of discriminatory behavior within his department. His behavior has cost us hundreds of thousands of dollars, yet he demanded a raise and more money each year for the department. He used public funds for investigations strictly to benefit himself, and he leaked it to numerous people, though we can't even validate that what he leaked was even true. All in order to destroy this man. The man we should be calling sheriff. If the good old boys don't like him, he's doing something right. Bryan has been fighting this county just like so many of us for years. He shouldn't have to fight for your vote. With Bryan, Itasca has a chance at real change. He's determined to audit and investigate the corruption and hold those responsible accountable. Something the other candidates can't or won't promise. They've only agreed to audit. Why? Without accountability, what good is transparency? Give Itasca County the opportunity to rid itself of the current regime. Vote Bryan Johnson, Itasca County Sheriff, for the win 2022.